Hello, and welcome to today's health webinar. This episode is brought to you by our friends at Ropes and Gray. We would like to remind you that the Q&A feature is available, so feel free to send in your questions and comments throughout today's webinar. We would love to hear from you. And with that, I will turn over to our speaker, Christine Moundas.
Thank you very much, and thank you for joining me today. As the introduction noted, today's webinar is going to cover the new state consumer data privacy laws, and in particular, implications for life sciences and medical device companies. My name's Christine Moundas. I'm a partner at Ropes and Gray. I'm in the healthcare group, and I also participate in our data practice, and I co-lead our digital health initiative. A lot of the work I do is for life sciences and medical device companies around issues of data privacy, data security, digital health partnerships, and other initiatives. So today I'm going to talk about really a burgeoning area of new law that is really having huge implications for these companies. So we're going to start off with the consumer data privacy landscape. Then we'll go to key features of consumer data privacy laws, compliance obligations for businesses, and then practical implications, what clients should do now. So just to kick it off, I wanted to provide just an overview of the explosion of these laws over the past few years. First, let's say it all really started in 2020 when CCPA, the California Consumer Privacy Act, went into effect. And really at that time, folks were trying to adjust their data privacy programs to address CCPA alone. But then soon certain states started, creeping up. And in the course of 3 years, we had a few states come online, like Virginia, Colorado, Connecticut. But then you turn around, and then in the past 2 years, a huge number of states have come online. So at this point, we have nearly almost half of the states having their own comprehensive data privacy laws, which did not exist before. So this is really a really huge explosion of a whole new area of law that really impacts a huge amount of the economy. Now here's a slide from our Ropes and Gray tracker where we tried to note, what are the states at play? What are the different types of laws? We have some that are comprehensive consumer privacy laws. We have some that are inspired by the comprehensive consumer privacy laws, but are a little bit different. We have certain states that have consumer health privacy laws and others that have sort of combinations. So just to say, and this is taken from a very helpful chart from IAPP, all these states are really trying to regulate and govern data privacy and data consumer privacy rights in different ways, but there are a lot of similarities between the state laws. So I've really tried to tell my clients now that it's gone from, a trickle to an inundation of states to really not just focus on one law here, one law there, but try to really zoom out and think about, okay, in aggregate across the board, what are these different states looking for, and try to spot the themes and try to now create a data privacy program that's more comprehensive in nature, given how these have all piled on. So here, there's consumer rights. These are just examples of the way that things have grouped, but the right to access data, the right to correct data, the right to delete data, the right to opt out of certain processing, right to opt in of sales of data. And this one we'll talk about a lot more later, but the right to opt in for sensitive data processing is really a huge change that really impacts pharma and medical device companies, in a major way, because sensitive personal data includes health data. So now that there's an affirmative opt-in right in many, many states for that sensitive data processing, it's actually forcing an opt-in consent barrier that did not exist previously for companies processing health information. So that's really one that I think has sort of flown below the radar, but is huge. There's also other business obligations that we'll talk about, like risk assessments, notice requirements, having limitations on the purpose of processing, prohibitions on discrimination. really there's quite a number of obligations that companies need to follow. But again, trying to move away from our early sort of CCPA state-specific mentality to now seeing that this is a national trend that needs to be dealt with is quite important. Um, just to, this just further reiterates how this all has progressed over the past few years. And I don't think we've seen in many areas such an explosion and a steady march of the states in passing laws in such a coordinated manner. So this talks about, after CCPA, you had 2 states in 2021, another 2 states in 2022, and then we really saw an acceleration over the past 3 years, 7 in 2023, 7 in 2024, and then 8 went into effect this year. Again, here's another view of the state landscape at this point. So as you can see, we're now slowly covering almost the whole country. So relevant to pharmaceutical and medical device companies, in addition to the state consumer privacy laws that governs consumer data generally, we also now have consumer health data privacy laws that are broadening the definition of health data and imposing stricter requirements on collection, use, and protection. So health data now encompasses not only traditional medical records, and obviously it's much broader than just, HIPAA covered entities, PHI. We're now talking about companies that fall outside of that historic HIPAA framework, and then data that also was not historically thought of as governed data. And that includes inferences about people's health based on app usage, wearables, and online behavior. So in particular, we've been paying attention to Washington's My Health, My Data Act and Nevada's new consumer health data law. And we'll talk a little bit more about those laws, but we're now dealing not just with an onslaught of general data consumer privacy laws, but health specific ones as well. So here, despite the slowdown in new laws, there's now very active amendments to laws that continue. And we just saw some of these laws, we'll talk about them. They've been amended for new AI provisions. The President Trump just announced plans to potentially sign an executive order aimed at limiting the impact of state AI laws. So we'll have to keep an eye on that. It was previously threatened to be added to another bill earlier this year. And now it seems like he might not go through the legislative route, but may have an executive order aimed at laws that impact the, state AI-based requirements. So we'll have to see how that potential executive order interacts with those. So here's the key features of consumer data privacy laws. Again, I want to try to zoom out for folks and make sure there's a general understanding of really the most important requirements at play. So first, there's applicability thresholds for all of these state laws. So they all are either focused on a combination of the amount of personal data processed by a company, as well as a threshold of how much gross revenue the company makes. CCPA has a $25 million threshold, which most big companies, clear by a large margin. There's other states that have other revenue thresholds that are coupled with the personal data processed threshold. It's really important to know they're not concerned so much about whether you have actual physical operations in their states. They're concerned about whether you're engaging in commerce or engaging in transactions which result in actual collection of consumer data from that state. There's very broad definitions of personal information, and it's, generally encompasses any data can be directly or indirectly linked to an individual that's considered a consumer. As I said, there's this new construct of sensitive personal data, which most importantly for this industry includes health data, and now a new requirement that there's affirmative opt-in consent before processing of the personal data. There's core consumer rights, which I had previewed earlier. All of these now new core consumer rights are requiring new data compliance processes to actually make sure that you're making people aware of their rights, you're providing a mechanism for them to actually act upon those rights, and then you're actually fulfilling those rights requests to the extent they're legitimate. There's opt-out mechanisms that are now required, and in some cases, there's opt-in for secondary purposes requirements, which is another difficult and gray area to thread, particularly trying to suss out what's a primary versus a secondary purpose, which is, I would say, not always the cleanest analysis. Here, again, this is taken from another CCPA chart, which I think is helpful just for folks to get a sense of what the analysis looks like. As you'll see here, it's really important that first and foremost, a company tries to engage in some level of analysis of how many and why is a company triggering each of these state consumer privacy laws, and to refresh that analysis, I would say every 6 to 12 months. It's really important because one, it's a critical step in order to ensure that you know which states you're triggering, so then you know which obligations will be triggered. And it's also important because you need to take a position as to the applicabilities, so that if a consumer in a particular state invokes their rights, you may determine that you don't apply, that law does not apply to your company, and therefore you do not need to actually comply with the relevant requirements. Some companies take the position that they're offering data consumer privacy rights more generally now across the board, but others are still taking a state-by-state approach for when they're going to grant those rights. So this analysis is really key. I also think it will be an important part of the legal and compliance files if there's ever a investigation by any of the state-based agencies, and they're asking, why didn't you comply with our laws? If you have an argument that the law didn't actually apply, it'd be very helpful to have contemporaneous documentation actually showing that you did the analysis and you came under the thresholds. There's also, it's important to be aware, there's entity level exemptions from some of these laws, and there's data level exemptions. The one really important one, I would say, is the not-for-profit exemption, because I would say, and also the HIPAA exemptions. These exceptions to not include not-for-profits as being subject to the laws, and also not including HIPAA information. That is why a lot of healthcare providers and health systems, and even you see there's an exception for our higher education, so universities may not be subject to these laws. So when life sciences and medical device companies are interacting with healthcare provider or health plan entities even, on these laws, it's important to understand that the laws do not actually impact those organizations in the same way. So they might not even really understand what these requirements are because it hasn't applied to them and they haven't dug into it. So this is, it's difficult in now healthcare and life sciences because you have a very different set of requirements for these entities that actually interact quite a bit. And that is creating some difficult intersections where you have to figure out, okay, how are we going to, first deal with data potentially like in the HIPAA context, but then it gets disclosed and now it's in the state consumer privacy law context, and how are we navigating that switch where the same data in different organizations' hands is actually regulatorily treated very differently. So do not be surprised if you have to interact with a not-for-profit health system or university that they might not be familiar with these laws because they might not be subject to them. I'd said personal information is very broadly defined, includes name, address, phone number, email addresses, dates of birth, online identifiers, government or other unique identifiers, location information, and then, as I said, sensitive personal information. And then some laws even use a broad definition encompassing any information that either directly or indirectly identifies, relates, describes, or can be reasonably linked to a particular individual or household. So this is really a huge, scope creep in a way to think about it in that way. And then sensitive personal information is a subset of personal information, which often triggers additional privacy requirements. So here, when we talk about sensitive personal information, again, the definitions vary slightly, but to give you a sense, these states are interested in regulating health data generally, genetic data, biometrics, sexual orientation, precise geolocation as tied to these categories, racial or ethnic origin, sometimes even citizenship or immigration status, and more. And sensitive personal information may also include data collected via online tracking technologies that are used to build profiles based on health-related interests. So we saw, burgeoning enforcement in this area for early FTC cases, including the Flow app tracker. There's also, as I mentioned, there's HIPAA exceptions. So from a data-based exception, HIPAA data is generally not covered by these laws. And in some cases, HIPAA covered entities in general are not covered by the laws. So they're defined a little bit differently. There's also certain research exemptions. So we're not going to get into that too much today, but most consumer data privacy laws exempt personal data used in clinical research. So, but you have to be aware the exceptions are narrow and only apply to the personal data restricted within the scope of the regulated research. So it doesn't apply to sort of exempting the organizations more generally. So the core consumer rights, just to talk about them a little bit more, because this is really a very new paradigm, a very new framework, and it's not something I think this country is quite used to. There's now, to the extent these laws apply and a consumer has a relationship with a company that is subject to those laws, that consumer has the right to access their personal information that's collected, processed, or stored by the entity. Consumer also, depending on the state, has the right to know the names of any third parties to which their data is being transferred. If you think about those two things alone, right, in order to actually effectuate these rights, this means that a company actually needs to understand what data it collects and what it does with the data. Previously, there really have not been very tight controls around internal sort of data uses and data sharing. And this really is requiring a whole new level of organization and awareness internally for companies. And then in addition, it's requiring sort of external awareness for companies to understand their data flows and what third parties are actually transacting data with. I mean, when you get into pharmaceutical land, there might be hundreds, if not thousands, of vendors that actually might be involved in certain data flows for certain functions. So this is really these two things, even though you can read them and it seems straightforward, when you think of what's actually involved in getting to sort of the answer here, there's a lot of back-end work that needs to be done for organizations to have a better awareness of their data processing activities. Consumers have the right to correct inaccurate or outdated information. Consumers have the right to request that their data be deleted. Here, there's a lot of exemptions that can be invoked related to the data deletion requirement. So in the pharmaceutical and medical device space, given the posture of the way these entities generally interact with consumers, this largely gets the exemptions sort of swallow the rule for this one, but it's something to be aware of. And then consumers also have the right to request personal information in a common file format. And as I said, in terms of additional core consumer rights, I think the right to restrict a business's information to process the personal information about an individual or to opt out of them, including opt out of sales. This is really an important right, and we'll talk about how it interacts with the online tracking technologies as well. There's the right to opt in to sensitive data processing, and that is requiring a whole new area of sort of consent processes, notices, and really stopgaps with how information is being collected. There's a right to opt out of certain automated decision making. And I think it really depends. I think the industry is still sort of figuring out what things this mainly impacts. I would say we saw automated decision making more in the HR context, but we could talk about, you've heard other things around like mortgages and other things. I haven't heard as many examples in the life sciences and medical device space, but I think it's important to keep that in mind. And then in some states, there's actually a right of private action. So we will expect to see civil litigation around these issues in the coming years. So here, this is another sort of summary chart that shows how these rights are actually, how they pile up in the states. And as you'll see, there's a lot of consistency between these states. So even though you have one-off exceptions here and there, you're seeing a lot of green check marks here. So it's really important that folks get away from the state by state, oh, I guess we'll just do what this one state wants and this one state wants, and realize that this is now becoming an enormous trend. So let's talk a little bit about compliance obligations for businesses. So I try to think about, okay, we have all of these laws coming online or now in effect, and what does that mean for me? Where should I start, and what should I be focused on doing? And this list is not comprehensive, but I tried to basically get companies to work stepwise through this compliance process, because it's not easy, but you do not want perfect to be the enemy of good. You want to start actually working on something, even if it's not going to be perfect, and you have to keep, revising and refining. So I think first and foremost, developing external privacy notices that actually comply with all these laws is really important, because the privacy notices are public and other individuals can see them. So if they're out of date and clearly out of date and haven't been changed in, 3 or 4 years, it's going to be actually a message to the outside world that the company is not keeping up with the laws. And I think that will then, it could draw regulator interest as well as, individuals coming around to either launch complaints or try to stir up some private right of action type of suit. Creating affirmative opt-in consents at key parts of the data flow for the company is also really important. Again, pharmaceutical and medical device companies historically have been sort of one step removed from the consumer. But when you think about patient support programs, shipment of devices, fitting of devices, websites, patient applications, et cetera, there are different touch points where consumers are interacting with the company. So we really want to analyze, okay, where are the different touch points where we're interacting with consumers, and how do we insert an affirmative opt-in consent when we're dealing with the processing of their sensitive personal information. Establishing and implementing data processing agreements. This is really a huge obligation that needs to be worked on. We have requirements in many of these states that companies not only control how they process information, but when they hand information over to a vendor, that they restrict what their vendors will do with the information. These laws wouldn't really be any good if you restricted some companies, but the minute they disclose it to another company, there's no controls in place. So those data processing agreements are essential for flowing down the requirements and having the requirements follow the consumer data if it's disclosed to a third party. And I think this is where it's actually a huge amount of work to identify all the relevant vendors, identify the relevant data flows, and then start working to sending out the data processing agreements and negotiating them and getting them in place. Again, we try to at least take a risk-based approach where you are identifying, either the vendors with the highest risk data or the highest volume of data, and trying to focus on them and work your way through. It's important that you start to honor consumer rights. That both means, and we'll go through it in a little more depth, it means telling people what consumer rights they have, telling them how to reach the company, making sure you're actually monitoring what consumer rights requests are coming in, and then timely following up on them. And I will say one of the difficulties in this area relates to there being a lot of sham requests that come through, there being requests that don't validate the actual information that you need. So there's a lot of difficulty in this realm, but it's important to at least get going and have a sense of what are coming in and how best to respond to them. There is a new CCPA risk assessment requirement that we will talk about in more depth that I think really will change the landscape here. There's some existing requirements for data impact assessments that we'll talk about. And then there's also the concept of maintaining a focus on data minimization. So we'll go into these in a little bit more depth, but those are really the important ones. Okay, so on the next slide, want to show here that the developing external privacy notices, as I said, the external privacy notices are a very clear indication of whether the company is compliant and has a situational awareness of all these changes in the laws. So it's really important that the privacy notices are looked at, that there's US specific notices at this point, and that they're up to date. They should address the types of PI collected, how PI is used, collected, used, shared, or sold, the consumer rights, security measures that the business employs while not over promising, because that can then be used in litigation as a public statement or a public promise, state or sector specific disclosures, which are very important to address, talk about how the notice will be revised and updated moving forward, and then contact information for the company and contact information that's actually going to be, live and monitored and real. And just to say, the privacy notice requirements are distinct from the general consumer data privacy laws and the consumer health data privacy laws. So we are helping our clients create consumer health data privacy policies because that is a requirement under Washington My Health, My Data Act, and I think we'll be seeing that in other laws in the future. Okay, next slide. So again, I think the data privacy notice task is important. I think it's important to be strategic up front. There's different approaches to how you address this. Sometimes companies do a single unified notice that addresses all aspects of the business's personal information use. Some companies actually do different notices that are tailored to specific aspects of the business, such as ones geared to employees and job applicants versus customers versus other types of web visitors. So it's important to have a sense of how you want to structure it. And then there's different formats. You have long form notices. You can have a layered notice that provides customer with sort of a summary or abridged form of the privacy practices first and more detailed to follow. And then also just-in-time notices to provide consumers with a clear notice at the exact point of time in which their information is collected. Next slide. So again, creating this affirmative opt-in consent to when you're collecting sensitive personal information. Individuals really must actively agree to the processing of their sensitive personal information. And as I said, there's, this shows again how sensitive data is defined. This is really important that you actually know all the different, endpoints of where a company is pulling in this information. I would say when you think of pharmaceutical and med device companies alone, thinking about all the apps or websites they might have, some large companies, it's even hard because they have a bunch of branded websites. They're run by different vendors. Even getting a list of all the websites is a task, let alone all the different business functions that might involve the collection of sensitive information. But having a sense of that data map of how data is getting collected and then thinking strategically about how the opt-in can be implemented at that point in time is really, really important. And then there's also the issue of consent management and trying to monitor that. Next slide. Again, the data processing agreements, this used to be more of a GDPR-oriented exercise. Then when we had CCPA, a lot of folks were doing CCPA-specific DPAs, but now we're at the point where companies really need to implement broader DPAs that cover all these different laws and really are flexible enough to take into account future laws so that you don't have to go back every 3 months, every time a new law comes online to account for them. So these DPAs must, define the types of personal data to be processed, ensure that processes set up, fulfilled that those vendors help to fulfill data subject rights to the extent they're in possession of the data that's subject to the right. Has to specify engagement with any sub-processors and whether, you require approval of that or further flow down of terms. And then also, in some cases, then you'd want to talk about the security measures that they're using to safeguard the personal information that they're in possession of. And some places have separate, very detailed security addenda. So the approach to the more privacy-oriented DPA versus security addenda, that's something also that needs to be thought about. But really, also one of the primary purposes of these DPAs is to ensure that vendors are not doing anything with the data that really hasn't been consented to or that's not being permitted by the original company. So we're really trying to, control the way the vendors are handling the data so that it's not, a free-for-all. Next slide. So I talked about this, the honoring consumer rights. I will say we'll talk about it in a little bit, but um, the way different companies are actually setting up their privacy rights centers are quite different. Some companies, because their privacy program is not that well established yet, or just their exposure to consumers is more limited, they're doing a more, I would say, just plain vanilla type of, if you have a data privacy, request, email, privacy@company.com. Others are doing very plain sort of web forms that collect the information. And others are actually using more complex consumer data or privacy management systems that integrate on the back end with actual software that then the company is using to then store and manage those privacy requests. So trying to figure out what that approach will be for your company is really important. Are you going to take the plain vanilla, just reach out to us? Are you going to take the sort of next level web form, or do you actually need a whole sort of privacy rights center vendor? And there's some out there in the market. There's issues with some, pros and cons, and that's something that I help my clients think strategically about depending on their exposure. You also need sort of to think about other consumer rights vehicles like email opt-out links, website tracking opt-out links, which we'll talk about the sort of cookie management tools, others. There's also universal opt-out rights that need to be honored. If you have an app, shared settings or tracking settings are important to think about. And then even if the user's in an authenticated app, thinking about how they can request their information, et cetera, in the context of that app exchange is important. Next slide. So as I said, really thinking about in order to effectively honor consumer rights, you really have to start with a data map of some sort. And a lot of companies have struggled with this data mapping requirement. It's not easy. And I would say a lot of companies sort of get sort of 50% of the way through and kind of give up because it's too hard. I would try to say, have a roughly usable data map that tracks how data is used, and then you can always refine it over time. But don't sort of do it and then give up on the exercise and not pursue, because that's really an essential component to being able to customize your privacy notice and then be able to actually respond to consumer requests. Because if a consumer says, hey, I'd like a copy of all the information you have on me, if you don't know sort of how that consumer came in, what data is collected through that pathway, and then where that data goes, you're really going to have a hard time honoring that. So it's really important that all the data map sort of drives that first and foremost. And again, as I said, verifying consumer identity, that's a whole separate topic. There's restrictions on some of the states saying you really can't ask for more information than is necessary, but there's also been a lot of just random, not legitimate requests that come through. So it's important for the company to strike the right balance in terms of identifying whether a person is real and interacting with them. And again, there's deadlines associated with most of these things. So when consumer privacy right requests come in, you have to identify what state they're in very quickly, whether it's an individual that there's any record of, and then you have to know, okay, what are the deadlines that I'm dealing with? So all of that, and then tracking and making sure there's follow-up is quite important. Next slide. As I said, there's the right to opt out of different things, including the sale of personal information, targeted advertising or cross-context behavioral advertising, which is sort of called sharing of information under CCPA, and then of profiling. Again, I don't see that as much in the life sciences space, but you saw that more in sort of the mortgage and banking context, but we could, it's possible that there are some use applications there. CCPA also requires an affirmative opt-out of sale link on the website. So that's another thing that has to be implemented in the website. And again, some companies then have it linked to their cookie management tool, which is something to consider. Next slide. Okay, as I said, tracking technologies, which are bits of code that are installed on websites that can enable and usually interact with third parties, and it can enable tracking, retargeting, all sorts of things. This has been a very hot area of both regulation, enforcement, and a huge amount of civil litigation, which we've been dealing with. Essentially, tools like the Metapixel and Google Analytics, others were installed on so many websites across the country, primarily by business teams, hoping to engage in marketing analytics. But those tools actually grab a lot of information off of the websites. And there's been a lot of claims that using those tools is a form of wiretapping of communications by third parties. And these tools are also not HIPAA compliant, so that has caused a whole separate issue. But it's really important as part of the analysis of what information is being collected by the company that you understand how your websites are operating and if there's any online tracking tools on them, because that is a very externally facing knowable mechanism that class action plaintiffs firms have been looking at. And all the code related to the Metapixel or Google Analytics is all viewable. By the class action plaintiffs firms, by regulators, et cetera. So it's something that you need to understand because the rest of the world can see the code of your website. Next slide. So the consumer data privacy laws like CCPA, they regulate data collected via the tracking technology. So in the privacy notices, you actually need to describe what type of tracking is on and what it's for and what types of cookies are on your website and what are they for. You'll see, now a lot of companies didn't exist a few years ago, but now as you interact with websites, they'll ask you to accept or reject different forms of cookies, like necessary cookies have to run. Sometimes they're called functional cookies. And then there's more optional ones like analytics, which actually tracks how you interact with the website. And then advertising is another one. So because there's this requirement to opt in to the processing of sensitive personal information, if you have a cookie tool running on a website that's grabbing data before anyone can say anything, it's really important that you actually configure your online tracking technology tools to not fire until someone, if it's on a website that's related to health information or where health information can be inferred, to not fire until someone has accepted all cookies or accepted the category of cookies that are relevant. So this is where that opt-in right to processing of sensitive personal information and where online tracking technologies intersects. So This is an area where legal or compliance cannot do it on their own. They need to actually talk to the web owners, talk to the marketing analytics teams, and really understand what's loaded, who controls them, all of that. And a lot of times there's third-party vendors that control the websites or control the tracking tools, and there's not a lot of visibility or accountability with those entities. So it's really important to try to get a handle on that and to force that accountability and transparency and those functions that I talked about. Next slide. Okay, a new requirement that really, I think, again, some of these things are flying under the radar because they're changing so quickly. But when you stop and think about them, they're actually requiring a really substantive amount of work that needs to be thought about now. CCPA, there was new risk assessment regulations that were approved this past September and that will go into effect this January. So in 3 weeks, this will be in effect. Under CCPA, it's requiring businesses to conduct risk assessments before initiating activities that present significant risks to consumer privacy. Unfortunately, this significant risk as defined on the right, and you'll see that the bulleted list includes processing of sensitive personal information. So California is essentially saying any processing of sensitive personal information is a significant risk, and therefore you need to be conducting risk assessments before initiating any of those activities. And not only that, they're requiring that businesses submit information about their risk assessments to the California Privacy Agency. So this is, both requiring a huge amount of work, I would say, to get this into place, and then actually forcing a reporting to the governmental agency, which we've never seen before. So this is a really important new obligation. It's going to be difficult for companies to execute on. So I think it's important to try to think about how to make a good faith effort towards compliance on this so you can have at least a good faith argument that the company has tried as best it can to actually engage in these risk assessments. But this is really an area to watch because I think this is going to cause a lot of work in the industry that's going to, be more of a burden than I think even the regulators really appreciated. Next slide. So just to say what would be included in a risk assessment. So it's evaluating whether the risks to a consumer's privacy outweigh the benefits. And they must identify the business purpose for conducting the activity, the types of data that are being collected, how the business plans to conduct it, the benefits to the business and consumers, the negative impact, and the safeguards. So I think in most cases, if it's really a vital function, that's easy enough to sort of show the pros and cons. When you get into things like targeted marketing and other things, you can see that this analysis might be more difficult. And I think it'll really come down to having a very good, concept of data minimization for not processing or disclosing more information than is necessary, and then also having a really good story to tell on safeguards that have been put in place. But this is a really new and burdensome privacy function that is going to be starting the first of next year. Next slide. And just to say, we had talked about, what are the more difficult things that need to be analyzed. The selling of data under CCPA, that will be, a difficult one to analyze under the risk assessment framework. And there has to be, there's certain requirements around whether people were opting out of the selling or sharing of their information and making sure that those opt-outs are working and really trying to make sure that you are analyzing where does my company sell or share information? Because some folks might think, well, we don't sell information, so therefore we might, not do it. We're not selling it outright. But the concept of sharing information, including through cross-context behavioral advertising, where there might be valuable consideration, is in scope. So it's really important to look at. Next slide. There's also the concept of data impact assessments under some of these laws and sort of how the CCPA risk assessment process will interact with this data impact assessment process is also really important. So this is where you'd have to actually assess privacy risk before launching a new product, services, or data initiatives. And it includes many of the same requirements that we talked about in the risk assessment process, but it's actually triggered under slightly different circumstances. So on the next slide, we can go into like when are they triggering what? So the impact assessments, which are mainly under Colorado, Connecticut, and Virginia, is when activities present a heightened risk of harm. And a heightened risk of harm is defined as targeted advertising, sale of personal information, and processing of personal information for which there's profiling. Where California is saying whether there's significant risk, and that includes any processing of sensitive personal information. So I think the California's law is going to be, the risk assessment requirement is going to be triggered very, very frequently, and that the risk assessment process is sort of going to kind of subsume that impact assessment process. But this again is something that's going to have to be sorted out over time and implemented in a strategic way. Next slide. And then I talked about the focus on data minimization. It's really important if you're going to go through these assessments to have a very good explanation for why a company is doing what it's doing with information. It's important for business teams to really think strategically about, do you need to collect that information? Do you really need to send it to all those vendors? And do we need to be doing, X, Y, Z with it? So the purposes of, collecting and processing the information has to be reasonable, necessary, and proportionate to achieve the purpose. So collecting the minimum amount of information to actually fulfill the purpose that you're intending is really important. So it's not more is more, it's less is more over time. Next slide. Okay, so in this last section, we'll just go through some practical implications for what companies should do now. Next slide. So as I had mentioned, first and foremost, it's really important to assess the company's operations against the applicability thresholds. There's revenue thresholds and amount of data processed thresholds, and also amount of data sold or shared thresholds. You have to look at that, all of those for your company and figure out, okay, of half the states that have these laws, which ones are we triggering? And it'd be really helpful to put that in sort of a memo to file and then update it on a periodic basis. I have a chart that I share with clients that summarizes those applicability thresholds, and then I have my clients actually fill it out. So we have a record of that point in time. And given that so many new states are coming online, we then update that periodically. Then you have to really assess the company's data profile against the exempted data definitions and figure out how much or how little does that really impact your overall exposure to these laws. Then again, we have to conduct a data inventory and do an intake of how much data is coming into the organization. Then with that information, update the external privacy notices, update and implement any internal privacy policies that actually outline all these obligations and note what the company will do when different obligations are triggered, establish a privacy rights center of some sort, establish data processing agreements with relevant vendors, and then comply with the CCPA risk assessment submission and timing requirements that I noted before. So these are really just high level, really important activities that companies need to think of. Next slide. Again, as I said, for the assessing applicability thresholds, really first analyze, does your organization do business in a particular state? If you have broad websites available to the whole country, if you're distributing pharmaceuticals or devices across the country, you're likely doing business in all the states. do you target our market to resident in those states? Do you process information from individuals in those states? And what are your annual revenues? All these things are important to analyze and to note. And that'll be a point in time. Frequently, when I have companies that are just at the pre-commercial phase and they know that their product is going to get onto the market in the coming year, I tell them to start building their data privacy programs from the year before so that when they are actually commercial and bringing in revenues, they're already prepared for the obligations that will then immediately attach. Next slide. This is just an example of how to analyze the applicability of CCPA, but we won't go into too much depth. Next slide. Again, noting down the exempted definitions, it's really important to just understand that these states were purposely defining data very broadly because they wanted to fill really what they saw as the enforcement vacuum that existed, with really only the FTC being the main regulator that was enforcing in this space and not really a particularly active regulator around data privacy. But they did have important exemptions where they didn't want to duplicate efforts of already regulated data. So understanding the exempted data, understanding if you have parts of your operations in the medical device space, sometimes you have divisions that are HIPAA covered. Those divisions would be sort of outside of this framework. If you have a whole clinical research unit or clinical research activities, those would be exempted, and then you need to analyze what's left. And I would say generally patient support programs for pharma companies is a huge area that we have to look at. And medical device companies, it's really if they're interacting with the consumer base, analyzing those interactions as well. Next slide. As I said, conduct the data inventory, try to at least get to a reasonably reliable level of information about data sources, classifications of types of data, data transfers to third parties, etc. Next slide. For the updating the external privacy notices, choose the approach and format that you want, reflect the current activities, update it as best as you can, and then make sure to include language that allows you to say, we collect this type of data, including but not limited to, so that you're not being overly restrictive. It's when language is sort of too precise that you sometimes are making promises to consumers that are not accurate. So make sure you have appropriate sort of wiggle room in the disclosures you're making. Clearly disclose the consumer rights, have your point of contact, identify the third parties and purposes for which you're disclosing information, and then have a regular update process. These documents really at this point should be updated, I would say, every 6 months, because they're getting very stale very quickly, given the way these regulations and laws are changing. Next slide. For the internal privacy policies, I just want to speak to this a little bit. I do think it's very important that there's an internal policy set that's oriented to privacy and to some points IT security as well, but that actually states what the company's position is with respect to what laws it's actually addressing, defining roles and responsibilities, actually having specific procedures in place, having protocols for addressing data privacy rights, privacy incidents, complaints, having training and regular training just around sort of the folks that are responsible for these functions, as well as the company as a whole, and then periodically assessing the policies. I think the regulators are now going to get more and more involved in, okay, what's actually on the back end of these companies, of how are they actually adhering to all the things they're promising externally. Next slide. And the internal data privacy training, I think they're really, there haven't been as well-defined data privacy trainings that are role-based, and I think that role-based aspect is really important. So all employees need some level of privacy training, and that's really essential to try to get into annual trainings. But certain roles need process level training on how to implement privacy obligations into work streams. So it's important to figure out, okay, what are our key functions that we really need to do a deeper dive? Obviously, compliance, privacy, legal, IT security, and then thinking about some of the other core functions and how are they going to be brought up to speed on all these new obligations. I'd say procurement would be another one. These are a lot of changes that are now going to affect a lot of components in companies. And if you don't train them on what these new requirements are, there's no way they're actually going to keep up with all the procedure changes. Next step. Next slide. Okay. And then again, on the Privacy Rights Center, making sure that you have a user-friendly interface for the submission of forms, verification process, et cetera. This is really the entry point, and I think there will be ultimately different complaints and obligations around and investigations around how companies have either made it easy or hard for individuals to actually invoke their rights. Next slide. As we talked about, data processing agreements, they should be drafted now. They should be updated. If you had one in place that was just addressing CCPA years ago, that needs to be basically, redone entirely. So have a fresh look at your data processing agreements, establish each party's obligations, make sure there's requirements around what technical and organizational safeguards you're looking for, have all the requirements flow through, have some rights to audit their practices, and then get those out to your vendors. Next slide. Again, as I talked about this new CCPA risk assessment requirement, pay attention to this, read up on what's required. They just passed these regs a couple months ago, but now they will be in effect next month. Conduct your initial assessments, update them, catalog when you're doing them, and then be prepared to actually disclose how many have been done to CPPA or the AG upon request. And then also submit them annually moving forward. Next slide. And then key takeaways, enforcement is expanding, the requirements are expanding. There's going to be heightened scrutiny of a lot of different activities, including marketing, digital engagement, and compliance is critical. So it's really important that folks are taking all this seriously. Next slide. So, what's the strategy here? I'd say stay agile. This is a dynamic landscape. It's I think the most important thing is to show that you have a credible compliance program, a credible data compliance infrastructure. Embed the data privacy function, the legal functioning in all different parts of the organization so that you are able to monitor and update for your data privacy practices to actually address whatever's new to the company and make sure that you're addressing and mitigating risk. And then know that, strong privacy practices will ultimately build customer trust, and it will, lessen the potential impact of a regulator, investigating and then causing reputational harm. So with that, I think we will wrap up the webinar. I know we have one more slide or one more minute, but I know some folks have submitted questions, but I didn't have time for them today, but I will try to get in touch, and do feel free to email me. My email address is christine.moundas@ropesgray.com. Thank you all for joining today.
Thank you to Ropes and Gray and to everyone that joined us today. Please visit our website, hlth.com, to catch up on all health webinars and watch the recording of today's session. Join us in Los Angeles, February 22nd to 25th for Vive.